Thanks, Shona, and welcome to part one of the Corporate Insolvency Legal Update, your annual review of the key corporate insolvency cases and developments of the last 12 months. And unlike in some previous years, there have actually been quite a number of corporate insolvency decisions issued by the Scottish courts over the last year. So I'm going to focus today primarily on those Scottish decisions. However, before turning to those cases, it would be remiss of me as part of the legal update not to briefly mention a couple of other developments that we've seen both here in Scotland and in England. The first is the Movable Transactions Scotland Act 2023, which I'm sure most of you will by now have heard of. It's the act that's going to make it easier to assign rights and take fixed security over movable assets. And because it will be easier to take fixed security over assets in Scotland, the number of creditors holding such securities is anticipated to increase. So insolvency practitioners will require to be alive to the ranking implications of that, including in relation to their own fees. Now, although the Act received royal assent in June, it isn't expected to come into force until next summer, so expect plenty of legal briefings on this key piece of legislation between now and then. The second development is the slow but steady rise in use of the Part 26A restructuring plan, which was introduced back in 2020. The latest insolvency statistics tell us that there have been 24 restructuring plans in total, 12 of which, all English, were registered in the last year. So it's certainly a tool that's been used more frequently. And that's meant a number of decisions this year from the English courts on whether or not to sanction a restructuring plan. And a key feature of a restructuring plan is, of course, the cross-class cram-down, which is the ability of the court to sanction a plan and compromise a company's debts, even if there are dissenting classes of creditors. It probably won't surprise you to learn that HMRC have been objecting to plans which seek to cram down on the debts due to them. And there have been 3 decisions this year which dealt with HMRC challenges. The names of the cases I've put there on the slide. In 2, the court refused to sanction the plan, where the cram-down would have been unfair to HMRC, and the 3rd, Prezzo, where the court did sanction the plan, holding that HMRC's treatment wasn't unfair. So if you're involved in any way in restructuring plans, although there have only been 2 to date in Scotland, these 3 cases from the English courts are a must-read. But back to Scotland and the first Scottish case that I want to look at this morning, and it's a very interesting decision of Lord Braid in the Court of Session from December of last year. It's the case of Assertis against Cheryl Dunn, which concerned a gratuitous alienation challenge under Section 242 of the Insolvency Act and the defence of adequate consideration. As most of you will know, if a defender can show that the alienation was made for adequate consideration, then that provides a complete defence to any challenge to the transaction. Briefly stated, the facts of the case were this. The company entered administration in February 2020. In the 2 years prior to the administration, the company had made various payments to the defender, totalling around £583,000. The company had never been solvent, and it appeared that no adequate consideration had ever been received by the company in respect of these alienations. On the face of it, these payments were gratuitous alienations and therefore challengeable by the administrators. The administrators then assigned these claims to the pursuer, who raised proceedings seeking repayment of this sum from the defender. And by the time this case came before Lord Braid for debate, the defender was offering to prove that the alienations had been made to her for adequate consideration. And the core issue which Lord Braid had to consider was whether or not the facts and circumstances which the defender was relying upon could ever amount to adequate consideration. So what were they? Well, while the judge described the defender's position as confusing and contradictory, the key part of her defence was that she'd entered into an agreement with the company in terms of which she would introduce investors in return for an entitlement to charge commission of 25%. Her position was therefore that she had introduced significant investments to the company, that she would have been entitled to significant commission on those investments, and that her entitlement to commission would have been in excess of the amount of the alienations. There was, however, as the pursuer argued, no attempt by the defender to link this alleged consideration with the specific alienations. So by way of example, while the defender averred that an investment of £1 million had been made, which would have entitled her to commission of £250,000, there was no offer to prove that any of the particular alienations related to that commission. It wasn't sufficient, the pursuer argued, for the defender to simply aver that she was due more money under a separate contract with the company than the amount that she'd received from the alienations. Instead, she had to aver a clear link between the alienations and the consideration. So could those facts and circumstances ever amount to adequate consideration? Well, Lord Braid started his analysis by going back to the ordinary meaning of consideration as being something which is given in return for something else. A defender has to be able to aver and prove a link between the alienations and the consideration. And you can't, he said, retrospectively create that link. The parties must have intended at the time of the alienation that it should fulfill the obligation to pay commission. And in this case, the judge was of the view that the defender had made no attempt to link any of the payments made to her with any commission to which she was allegedly entitled. The defender's own pleadings also confirmed that the alienations were not, at the time they were made, intended to be payments of this commission. In summary, the defender's defences did no more than aver facts and circumstances from which a liability to make payment of commission might have arisen at some point, but not that the liability had arisen or that the payments made were in respect of that liability. As such, the judge concluded that the defences did not relevantly aver that adequate consideration, or indeed any consideration, had been given by the defender in return for the payments made to her, and accordingly he granted decree in favour of the pursuer. Now, I think this is a very helpful decision for IPs and, of course, litigation funders to have reference to, as it's a good example of the courts really scrutinising in detail averments which purport to make out an adequate consideration defence, and the willingness of the court in appropriate cases to grant decree at debate and without the need for proof. To be a creditor or not to be a creditor, that is the question. And it was the question which Lord Erich had to consider in the next case this morning, in the Note by Specs Group Holdings Limited from September last year. Or more specifically, the question which he had to consider was whether a creditor whose claim had been rejected by the liquidator had a right to appeal against the adjudication of another creditor's claim. Now, the creditor Respects Group Holdings, they presented a note seeking directions from the court, and the other creditor was MCR Oil Tools. And when this note came before Lord Erich, the issue and dispute between the noter and MCR was whether the noter had a right to appeal MCR's claim, even if their own claim had been rejected, the liquidators taking a neutral stance on the point. Now, the relevant provision for appeals in the 2018 rules is Rule 7.195, which provides that any creditor may, if dissatisfied with the acceptance or rejection of any claim, appeal to the court not later than 14 days before the end of the accounting period. Now, there was no dispute that the word creditor included a person whose own claim had been rejected and who wished to appeal against that decision. But the question for the court was whether the word creditor included a person whose own claim had been rejected, but who wished to appeal against the decision in respect of another creditor's claims. The noter submitted that on the plain wording of the rules, a creditor whose own claim had been rejected was entitled to appeal in respect of another party's claim. However, MCR disagreed with that. They submitted that once a party's claim had been rejected by the liquidator, they ceased to have any interest in the liquidation, became what they called a stranger to the process. They submitted that that was the situation in England and that it couldn't have been the intention to allow a rejected creditor to put others to the expense of an appeal. Now, the court's starting point was to consider the wording of the rule, with the judge noting that it applied to appeals against any claim and therefore wasn't limited to the decision on the creditor's own claim. In his view, the word creditor in the rule had only one meaning, and it didn't have a different meaning depending on whose claim was being appealed. To use his words, a creditor is a creditor. He therefore held that a creditor whose claim had been rejected did retain a right to appeal against the adjudication of any other creditor's claim and not merely their own. The judge also wasn't persuaded that the position under English law should be followed in Scotland, noting both the different wording between the Scottish and the English rules on this point and a lack of authority on the position being different in England anyway. So while appeals by a rejected creditor against the adjudication of another creditor's claim may in practice be fairly rare, we do at least have a very clear decision in terms of the Scottish position on this point, albeit one which may differ from the position in England. The next case I want to look at considers when should a Scottish court order the winding up of an overseas company. And that also happens to be the opening sentence and question posed by the Inner House in its opinion in the appeal in the petition by Kingston Park Limited for a winding up order in respect of Granton Commercial Industrial Properties Limited, a decision from back in December. And as the court notes in its judgment, it's not a question that has often arisen. The factual background to the case was this. Granton are a Jersey registered company. Granton owed Kingston, an English registered company, a significant sum in excess of £7 million advanced under a series of loans. Those loans were advanced to allow Granton to purchase a number of plots of land in Edinburgh, and those plots were Granton's only significant asset. Granton then defaulted on the loans, and Kingston petitioned the Court of Session for a winding up order in respect of Granton on the basis that they were unable to pay their debts. At first instance, the Lord Ordinary granted the winding up order, but Granton appealed, arguing that he had no jurisdiction to do so. Hence the question posed by the court: when should a Scottish court order the winding up of an overseas company? Now, the starting point was section 221 of the Insolvency Act, which confers on the court a discretionary power to order the winding up of an unregistered company such as Granton. The court then looked at the principles which had been developed over the years as to how they should exercise that discretion, principles which have come to be known as the three core requirements, namely that there must be a sufficient connection with Scotland, that there must be a reasonable possibility, if a winding up order was made, of benefit to those applying for the order, and finally, that one or more persons interested in the distribution of assets to the company must be persons over whom the court can exercise a jurisdiction. At first instance, the judge held that all three requirements were satisfied, but what did the Inner House make of them on appeal? Well, there was no dispute on the first requirement, given that the only significant assets were in Scotland. As to the second, Granton argued that as Kingston had standard securities over the plots which they could enforce through calling up, there would be no substantial benefit to them in a winding up order. The court, however, held that this requirement was clearly satisfied and said that it wasn't for the court to weigh up and compare the advantages and the disadvantages of winding up versus calling up. And as regards the third requirement, for two reasons, the court held that the Scottish courts could exercise a jurisdiction over Kingston, who, remember, were an English registered company. Firstly, section 4261 of the Insolvency Act means that any orders made by the Scottish court in Granton's winding up would be enforceable against Kingston in England, and therefore Kingston were in effect subject to the jurisdiction of the Scottish court in relation to insolvency law. And secondly, Kingston, of course, held standard securities over the plots of land in Scotland, and any dispute in relation to those securities would be subject to the jurisdiction of the Scottish courts. So all three core requirements were satisfied here, with the Inner House stating that they should not be applied as if they were hard-edged rules of law. They were instead simply factors that may be relevant to the exercise of the court's discretion, depending on the particular facts of the case. In summary, the Inner House said that stepping back from the points of detail, it's clear that there are strong connections with Scotland and that winding up is entirely appropriate. However, from a case where it was entirely appropriate for the Scottish court to make an insolvency order in respect of an overseas company to a case 6 months later where the judge came to a different view, albeit in different circumstances. And this is a decision of Lord Sanderson from June of this year in the petition by Münchener Hypothekenbank, I think I've got that right, for an administration order in respect of 17 Yellow Crowns, a Luxembourg registered company. The facts in this case can be stated relatively briefly. As I mentioned, the company was registered in Luxembourg. However, its only significant asset was a property in Glasgow. The petitioner provided the company with a loan facility and took a standard security over the property. The company then defaulted on repayment of that loan. And on the 13th of March of this year, the petitioner presented an administration petition to the Court of Session. The company itself then applied for a bankruptcy order in Luxembourg, and a bankruptcy trustee was appointed by the Luxembourg court on the 22nd of March. And it was the bankruptcy trustee who opposed the granting of the administration order. Now, as a starting point, there wasn't any dispute that the Scottish court had jurisdiction to entertain the petition or that the requirements for an administration order were satisfied here. There was clearly an inability to pay debts, and an order was reasonably likely to achieve the purpose of the administration. It was also accepted, as we saw in the last case, that the court has a discretion when it comes to granting the order. And although referred to, there wasn't really any argument over the three core requirements, which we saw in the last case. The real question here was how the court should exercise its discretion. And the petitioner argued that an administration order was the most pragmatic way to deal with the realisation of the company's only asset situated in Scotland. The proposed administrators, it was said, were experienced Scottish IPs. They were well versed in the marketing and sale of Scottish property. And in contrast, it was argued that a sale by the Luxembourg trustee would likely be more time-consuming and expensive, and it would require prior approval by the supervising judge in Luxembourg, which would involve further time and cost. On the other hand, the Luxembourg trustee argued that it wouldn't be desirable for there to be two concurrent sets of insolvency proceedings to be running in relation to the same company in respect to the same assets but in different countries. There wasn't any reason why he couldn't properly and effectively carry out the sale of the Glasgow property. He didn't need the appointment of IPs in Scotland to assist him with that, and as he had both the necessary powers and significant expertise and experience dealing with bankruptcies of companies owning heritable property abroad. In considering how to exercise the court's discretion, Lord Sanderson said that it appeared to him that this court should only install an insolvency practitioner in competition with one already in place by a foreign court of competent jurisdiction if there is some matter attending the appointment of the foreign practitioner which this court ought not to tolerate, or if the ability of the foreign practitioner to perform his appropriate functions in this jurisdiction can be shown objectively to be likely to be offended by such difficulties as to make the installation of a domestic practitioner an expedient course of action. And with that in mind, the judge was of the view that there was no obvious merit in the suggestion that the sale of a Glasgow property by the trustee would be more expensive or time-consuming than a sale by Scottish IPs. He said that the steps which would require to be taken and the professional advisors which would require to be engaged would be the same regardless of which IP was in control of the process. And he also made the interesting observation that communication difficulties, which might in years gone by have been caused by the distance between Luxembourg and Scotland, have been removed by modern technology. So in refusing the administration order, he concluded that in the circumstances, there was no objectively good reason to set up an unnecessary and undesirable competition between IPs when there was already an IP in place. And that's us come to the end of part one of this year's Corporate Insolvency Legal Update. I look forward to speaking to you again tomorrow when I'm going to take a detailed look at the decision of Lord Braid in the petition by the former administrators of Future Renewables Eco plc for approval of their remuneration and outlays. But in the meantime, back to you, Shona.